Hello, we're starting a new blog series today, and we're going to be addressing over the next few blogs the issue of jurisdiction in a military divorce. And this is going to be somewhat limited to where the proper place to file a divorce or the proper state, not necessarily related to issues of personal jurisdiction, etc. That's perhaps a separate issue. But what we're really going to be focusing on is which state is the proper state in a military context to actually file your divorce. So in Wisconsin, the standard for a divorce is that you have to be a resident of Wisconsin for 6 months prior to filing, and of the particular county in which you're filing for 30 days prior to filing. There are some other provisions that may permit a little bit of a different option, but for the most part, that's what we're going to consider for right now. But then we have to address specific issues related to a service member because we've got issues, obviously, where service members and their spouses, due to military orders, are somewhat transient. For example, the service member may enter the service in Texas, receive orders for California, receive more orders for Georgia, and then get married in Georgia, but then the question becomes, what is the proper state to file the petition for divorce? So the first thing to consider is that, pursuant to federal law, a service member does not either gain or lose residency in a particular state based solely on his or her orders. There may be other reasons that they gain or lose residency, but it won't just be because they've received orders to go to a different state. The military does keep notice of what's called a home of record for each service member, and that is generally the state where the service member entered the military, where he or she votes, and where he or she pays taxes, not necessarily where the member lives at any given time. Home of record may confer jurisdiction, but the main question we're talking about in determining where the proper state to file a petition for divorce is the concept of residency. And generally, residency is defined as a place where a person has been living for a period of time and intends to remain there as a permanent residence, not just a vacation, not just sort of passing through for a couple of weeks or a couple of months, but somewhere where they have established some permanent long-term, or at least long-term ties. So the question becomes then, how does one establish residency, or if there's a question in a divorce case, what information is going to be useful in determining where a person is a resident? So we've already talked about a couple of them, where the person votes, where's the home of record, where they pay taxes. Another question may be whether the service member is in a particular state due to orders or for some other reason. Do they own property? Where is their driver's license? Do they have bank accounts in a particular state? Again, do they own real estate? Where do they get their bills sent? Where do they receive their mail, etc.? Another option is utilities, where their car is registered, things of that nature. So when the question becomes where does a person have residency, it's a fact-intensive question that the attorney should discuss very carefully with the client, because it makes no sense to file a petition for divorce only to engage in a long drawn-out battle over whether the filing state was in fact the proper state. Because in some cases, in military cases particularly, there may be more than one state that has actual jurisdiction of the case. So we'll continue to address this issue of jurisdiction over the next few blogs, because it is a vital issue that gives the court the initial authority to handle the case. And if this part of the case and the filing isn't done properly, anything that comes afterwards may very well be invalidated at some point. So look out for the next blog, and we'll see you soon.